Hey everybody, and welcome back to the channel. I hope you're doing well. So today we're going to move into the next case in the constitutional law series of Bowers v. Hardwick. Now, this is one of those times where I like to remind everybody that judges are people, good, bad, and everything in between, and sometimes judges don't get it right. Sometimes when they don't get it right, they get it really wrong, and at least in my opinion, this was one of those cases. And not necessarily even because I disagreed with the outcome, but I've always thought the analysis was rather slipshod. But you'll have to let me know what you think on that subject at the end of the video. You'll see the reason why I think so more in the next video, which is Lawrence v. Texas, which most of you have probably heard of, and it's the anti-sodomy law case that came out of the aptly named Texas. So if you like this video series and the other work that I'm doing, do me a favor and hit that subscribe button. That way you get notified of when I post new videos. I'm trying to be a little more consistent and do it twice a week, but we'll see how it goes with work. And if you like the video itself and the other videos that I do me a big favor and give that like button a little thump until it turns blue. It really does help with the algorithm so that more people can see the content. So let's go ahead and get on into this particular case. Hardwick was convicted in August of 1982 in Georgia on their anti-sodomy statute. He described himself as a practicing homosexual and was caught out, shall we say, having a consensual sexual relationship with another adult. You will notice when I talk about the same-sex cases in this series, that phrase comes up a lot, and it becomes more important as these cases go on, talking about basically the ability of adults to make choices for themselves. So if you notice that I'm saying it often, there is a reason. In this particular case, the court found that the question they needed to answer for themselves was whether or not the federal Constitution conferred a fundamental right upon homosexuals to engage in sodomy, invalidating the law in not only Georgia, but in other states that made that conduct illegal. So this particular court started out its legal analysis with a little bit of a snit, and made a point of writing out all of the reasons that they took exception to the prior courts having taken previous case decisions to mean that the Supreme Court had conferred the right of homosexuals to engage in sodomy within that right of privacy. The court took the time to say that no, they had done no such thing and didn't approve of the lower courts saying they had. In looking at the previous cases, many of which we've been discussing, so Griswold, Eisenstadt, Roe, and the like, the court found that there was no connection between marriage and the child rearing that was discussed in those cases and homosexual sex for our purposes here to try and draw a connection between the two. In short, the court said that any kind of private sexual conduct between consenting adults is constitutionally insulated from state prescription is unsupportable. In continuing its analysis, the court started looking around to identify the nature of a right that would deserve what amounts to heightened judicial protection. So in the previous cases that we've talked about, that's been privacy, and what privacy means in relation to things like having kids, getting an abortion, and other issues. And they set the bar really quite high when they said that the category of such a fundamental liberty is that it's implicit in the concept of ordered liberty such that neither liberty nor justice would exist if they were sacrificed. That's quite the bar. And in looking in the prior case law, the court came to the conclusion that there was no formulation of such rights that could be applied to homosexuals being able to engage in sexual activity that they preferred, in this case, sodomy. From here, the court took a look at history itself, reaching back, as they said, into the ancient roots, noting that sodomy was illegal in all of the 13 original states. And at the time the decision was being made, 24 states and the District of Columbia still had anti-sodomy laws on the books between consenting adults. And the court took some pains to discuss the fact that they had concerns And some of those concerns were grounded in the fact that the court is vulnerable to criticism and a lack of respect, illegitimacy, if you like, when, as they put it, the court starts dealing in judge-made constitutional law, right? When they start making up stuff that isn't actually written down. And they were worried about extending this right to privacy to homosexual sexual activity on those grounds as well. Now, if you remember back in Griswold, one of the things the court did was look at the First Amendment cases, those German language cases when they were originally discussing the right to privacy and that penumbra. Well, Hardwick, in this case, his attorney also looked to the First Amendment to make arguments for their position. In this case, Hardwick's attorneys argued that this would be similar to the First Amendment obscenity cases that made it clear the government isn't able to outlaw you reading porn in your house. It'd be a First Amendment violation. The court didn't buy that particular argument and said, that's nice, that's the First Amendment. We're not talking about the First Amendment here. And then they took a further step and said, otherwise, criminal acts don't get a gloss. Just because you do something in your house doesn't mean that it's legal. Things like drug dealing can occur in your home, and it's still illegal. You can kill someone in your home. It's still illegal. Just because under First Amendment grounds the court can't prevent you from consuming pornography in your house doesn't mean that we can't prevent you from doing other things in your house. We then saw the wonderful tried and true homosexual getting blended in with other activity discussion. Forgive me for a bit of editorializing there, but the court went out of its way to make the argument that it would be exceedingly difficult for them to carve out a space for homosexual individuals to engage in consensual adult sexual activity while still leaving other sexual activity untouched and illegal. And they specified in their discussion activities such as incest and adultery. Hardwick's last shot across the bow, his final attempt, was an argument that the law itself had no basis. It had no basis other than morality and a dislike of homosexuals on their face. Basically, Hardwick said, and forgive me, it's just you don't like gay people, therefore you're making sex between them illegal. And morality isn't a good enough reason to ban the activity. And as I'm sure by this point you figured out, the court was also unsympathetic to that argument and said point blank that morality has been the basis of law throughout history. This is nothing new, and it's a perfectly fine reason to make something illegal. And as a result, the court found that the ban on homosexual sodomy was legal. The Constitution, as they put it, did not confer a fundamental right upon homosexuals to engage in sodomy. So that is the Bowers case. One that when I first read it, I was alone in my apartment yelling at my book for a solid 45 minutes because it's just so sloppily written, in my opinion. I disagree with the outcome for a whole host of other reasons, but the argumentation is just sloppy and loose and, in my opinion, driven by the desire for the outcome to be what they found it to be and then trying to backfill, Forgive me, normally I don't give my opinion in these case discussions. I generally prefer to leave the cases to speak for themselves, but there's few things that annoy me more than sloppy argumentation that gets turned into law. But do let me know what you think. Did the court get it right? And if so, why? I'm always up for the conversation. If you disagree with the court, why? Go ahead and reach out with your comments below. So I hope you enjoyed this case, and we will be covering Lawrence v. Texas next. Until next time, everybody, I hope you have a good one.